Hey, everybody, this is Greg Doss of GDNAPSC. Not an attorney, don't have a license to practice law, don't practice law, don't give legal advice. If you feel you need legal advice, consult with an attorney and be legally advised. Now, this is part 2 of my Greg Beats a Traffic ticket, and it's related to the case out of Hillsborough County, which was 14 CT 66525. And what you're going to hear in this is an interchange between myself, Judge Conrad, who does an outstanding job guiding me through the process, and you're even going to hear me use language and make reference to a bunch of statutes and a bunch of codes, which I do know them, but the context of their usage may have been a little off at this time, particularly in my journey, at this time of my journey. But what I can say is I'm appreciative to the ancestors, the Most High, and everybody and everything else that made it possible for me to get through this process without becoming a total jackass along the way and losing the case. But the context and the substantive issues of the case, of the case itself, I did manage to stay on track with. So as we go through this, and again, everybody's case may be different, but what I'm here to show you is that as a self-represented litigant, a pro se, there are ways that you can win cases on your own. I don't necessarily suggest it, but if you ever find yourself in a situation you may need our help, again, go to the website, go to gregdoss.com, or you can contact me directly and we can see what we can do based upon the facts of your case. So let's get to this case, which is my June 10th. It would be a motions hearing, and we'll pick it up from right here.
What's the charge? What's the charge? No, what's the charge? I don't have the file. All right, Mr. Doss, I don't remember when you were here last, but I know you've been in court at least one time before, and I indicated to you that if you had any issues you wanted to address with me, legal issues, you can go ahead and request a hearing aid, and you've done that. I have a copy of a notice of hearing and notice of special appearance that's been filed, and I have a demand for dismissal of actions that have been filed. Are those the things that you filed up to now?
Yes, sir. As well as, which I don't know if it necessarily applies to you, I also did a notice of constitutional challenge to the statute and a motion to intervene, which I've already certified a copy to Pam Bond, yet certified a copy to the state's attorney. Now, this challenge to the statute, probably at the time that I may have thought that it mattered, is probably I need to learn through the internet, through some other source. But if you read the constitutional challenges to the statute, you'll find out, particularly relates to state law, that the court can just summarily get rid of your challenge to the statute, and this request for intervention probably is going to take you nowhere. I would say, as you're going to find out, as Judge Conrad directs us as we go through this process, stick to the issues of your case, the rules that are related to your case, come to a good legal analysis, and then use a conclusion that will get you the remedy that you seek. You also have that as well. Okay. So
I don't know. Is that set for today?
Well, the motion hearing is, but the notice to challenge the statute, I don't think would have been necessary because they haven't provided discovery, so I'm just asking for a motion to dismiss on grounds of their failure to provide discovery.
Okay, well, let's do this. Let's start with, because all I have is a demand for dismissal of action, and I'll let you entertain, if you want, those. I don't know if there's a separate, it looks like you may have a separate demand for dismissal based on various grounds that look like maybe 1 through 11, and I don't know whether that corresponds with your motion or not. So you go ahead and tell me, if you want one at a time, what the reasons are that you think the case should be dismissed, okay?
Okay, well, I want the record to reflect I'm here still in the special appearance, which is on the record. I know you didn't mention it, and I'm here in appropriate persona. The first issue is that pursuant to Article 3 of the United States Constitution, there has to be a certified delegation of authority order on the record signed and authorized by Congress to certify this as a legitimate court, as well as Title 28, Section 3002 of the United States Codes. I've asked for. I'm going to say this as we move along into this case. He's going to come back and we're going to cover where federal law applies and where state law applies. And again, this is early on in my journey, and he's going to clean up a whole lot of the confusion along the way. I'm not going to interrupt it too many more times, but I just thought it would be better for me to give you a narrative as we go along with this proceeding. And it may not be the same that you hear from an attorney or from some other people who may have gotten their remedy through other means, but whenever there's an issue of a state court or state crime or state law, before even a federal court would even matter, you'd have to exhaust all of your state remedies before you can think about moving into federal law. And really, it doesn't apply in most of the instances, particularly as a traffic case is concerned. So keep that in mind as we move along with this June 10th, 2015 hearing. Specific things, one of which is that because if you can't certify that you're authorized to bring the action, you can't bring the action. Under those grounds alone, the action should be dismissed at that point.
Does that section apply only to federal courts, do you know?
Well, no, it applies to this court as well, because if you're going to say you're a court, the courts have been defined by Title 28, Section 2002, which is easily obtainable.
Well, this is United States Code, that's why I'm asking the question. If it's talking about a court of inferior jurisdiction and delegation of authority signed by Congress, that would seem generally to apply to federal courts, and that's why I'm asking, do you have something that says it applies to all courts?
Any court, because the issue becomes at that point jurisdiction. So if you're claiming to be a court of inferior or any court of jurisdiction, that jurisdiction has to be proven. And I've asked for them to prove jurisdiction. One, I've also asked to tell me what's the nature and causation, which is what the discovery is about. And I'm sure the Brady case would cover that. They can't just say, I'm not going to give you discovery when I'm accusing you of something which you can't prove.
Let's go.
Now, Brady is applicable even at the state level, and that's some of the basic requirements that a prosecutor or the state, whoever's accusing you of an offense, would have to turn over information that they were going to use or they may use in a case against you. They don't have to give you all of their strategies, but there are fundamental requirements that they would have to give you in any criminal allegation. We get a little bit further into that, but I just wanted to point that out.
That's number 2. Those rules of criminal procedure you demanded. Did you get notice of discovery?
I did.
Did you respond?
I'm just waiting to be signed at my office right now. It's prepared, waiting to be signed.
Okay, when did you get the notice?
I don't have the file with me, Your Honor, so I can't say that with any certainty right now.
I can.
Yes, sir, go ahead.
The 2nd of May.
I can't confirm or deny that.
I can show you a copy.
The grounds for dismissal says that
No, I want to make a correction to that because I looked at the date. I thought
that's
it was
not correct.
No, sir. The date is the 2nd because you look on the back of the motion for discovery, the notice of discovery, the name for discovery. It's pretty clear. And actually, I
Do you have a copy of that?
I'm probably walking away from the podium and going back to the general gallery to get the information. And going back and forth between the gallery and him, it doesn't matter.
Do you have a copy of the writ of discovery?
Can I go look at the system right now?
Madam Clerk, do you have a copy of that that's been filed? According to this, there's a stamp that says it may have been received by the State Attorney's Office on May 2nd. I don't know if this is your stamp on the back of the document.
And that stamp would also correspond with the date that I filed the challenge to the statute.
But you don't have that that's been, the writ of discovery has not been filed in the court file, or it has been? Yeah, you have a copy of it, right? I'm sorry?
That is our stamp.
Okay.
I do have a copy when I realized that discovery had not been done.
Okay.
Immediately did it, and like I said, it's waiting to be signed at my office right now.
Okay.
I can't provide it until I sign it.
All right, so let's go, I can address that issue. So you filed a demand for discovery, a writ for discovery. Looks like it may have been received. Actually, it has not been filed. At least what the clerk is saying, that it's not filed. You may have given a copy of that to the state or hand-delivered a copy of it to the state, but they don't have a record that it's been filed in the court file. But the state was on notice to provide that. She said that's done. Based on that request, what's the legal authority for you to get the case dismissed?
The pursuant to rule, and actually rules don't matter when the Constitution is the issue, because the Constitution will pull the rule down. But in accordance with Rule 3.220, it's pretty clear that you have 15 days in order to provide adequate discovery. They've been noticed, and if they file the case and they're saying that there's a crime committed, I have the right to ask you what is the crime, and you don't have the purview of not telling me what the crime is.
Yeah, she's saying she's going to sign it and get you the information today. So my question is, given that information, what legal basis do you have to get the case dismissed?
It's beyond 15 days, and she's to severely take her word over mine. She says she has it, so she had time to file. If you had time to say that I committed some allegation, which we don't know who's saying I committed any allegation, you can't say, well, I'm going to respond to something this far down the road. That's actually unfair.
No, I agree with you.
That's violative of the Constitution.
I agree with you that you're entitled to the information.
And I don't think
But the question becomes, just bear with me, is that even if they don't comply within 15 days that the rule suggests, you're arguing that the case should be dismissed, and that's where I really need to find out why, in that period of time, why the case has to be dismissed. Now,
no, he's absolutely correct. What he's asking me for is, and you can take your notes on this, I made a request, and although he may have discretion to impose sanctions, and he'll go over this later on in the end, what I learned along the way is to find some binding authority that would have mandated that because they failed to follow the rules, which the rules of court do matter, people, that they didn't follow the rules, that simply them simply not following the rules is not necessarily a fundamental violation of the Constitution necessarily, and different facts can probably bring about a different determination by the court. But he's going to tell you, but before he issues sanctions, he can compel them. There's a whole bunch of other things can go on. But I just wanted to make sure I pointed out that the rules of court and rules do matter, as well as statutes matter, unless there is a clear violation of a fundamental constitutional right. But those things are, within the exceptions and the rules and the exceptions to certain rules. But for every rule, there's an exception, and for one exception, there could be several other exceptions. And these are other things that I've learned over the course of these 5 or 6 years, and a lot of it I've gotten through consultations with attorneys along the way.
order them and compel them to give you that information if they didn't timely comply.
Right.
And if they don't deal with that order to compel, I can sanction them. And whether that includes dismissal or not, I don't know if that would be appropriate.
Okay. It would not be appropriate in as much as they have taken ethics oaths as well. One, in accordance with Chapter 4, Section 3.8 of the Florida Rules of Conduct, Professional Conduct, which is not a constitutional issue at this point, but it's an issue relative to Article 2, because they're actually people who have fiduciary responsibility in Article 2, Section 5. It's clear with this. Now you're wasting the taxpayers' money. Because if there was in fact a crime, it should be easy to prove, and you should bring forth the information the first day I was here. And I asked for the information.
Right.
Now, on grounds alone, you can't give them the right to say, well, we're not going to do something at this amount of time when the rule is stated, and then extend it because there's a 14th Amendment issue, because now you're saying we're going to create a special rule that's going to violate the Constitution tells you.
You're arguing what I guess what you think should happen, and I need legal basis. I'm not.
You want case law?
Well, you would have to show to me. I'm not aware of any case law that says, and I've been doing it a little bit longer than some people, that says if they don't timely comply under the rule of criminal procedure with 3.220, that your remedy is dismissal. The courts actually take a different approach unless the nature of the violation is intentional or egregious or somehow fundamentally violates your right to a fair trial. That would be too extreme a sanction.
Okay,
That's my
I'll
general.
agree with that. But if you go to, I believe it's an ACES decision, because if the issue becomes a jurisdiction, once I challenge the jurisdiction, you can't move anywhere until jurisdiction is proven. We're going to do this in another time, another place, and you can search this a whole bunch of ways. This issue of jurisdiction that used to get banned about quite a bit is simple in most regards. If you've been served, if the action took place in a particular geographical location, the court's going to probably have jurisdiction. in this instance, does the court have the authority to hear the case with given jurisdiction? But do they have jurisdiction over the case based upon all the other factors? That could be something. But in this instance, I'll say this, that a lot of my bloviating in this case, at this time, was because of my ignorance. Now, I obviously had some basic reading or studying understanding. Certain principles I understood because of my studying. You say that, and through that, I can recite quite a bit, and my other background helped me as well, from education to being a tutor to being a union steward, those things, being in the military, of course, shout out to the Army, a little bit, but that aided me in my understanding of the literature part of it, or the black letter of law, statutes, and things that I've read. The application part is what I gained through the several experiences, and even though I didn't really want them, but I did gain a lot of experience and a lot of knowledge, because not only did I go into the courts to do this, which you're hearing now, and many others, I also sat in on other court hearings and other court proceedings that were unassociated with me or unrelated to me or anybody I knew, so that I could kind of watch how the courts operated, how attorneys postured themselves. So I spent a lot of hours doing observations of different cases, and it helped me along the way. And again, certain consultations with attorneys, how I feel about a lot of them personally doesn't really matter. But many times you can get some pretty good information, even if it's information to tell you what not to do. And as far as the 3.220 violation of the not having 15 days, there could be an argument for appellate purposes for a delay in justice, but that's a little bit something we'll get to down the line in some future videos. But let's pick it back up, and I don't want to drag this 35-minute session out to 2 or 3 hours. Claiming that the crime has been committed, then we have the issue of corpus delicti, and then we also have the ulterior health care component as well.
Let's start with the, because I'm going to have to rule on these one at a time. So in terms of the first argument, Article 3, in accordance with 28 U.S.C. 3002, you're suggesting that as an element of going forward, they have to prove upon demand that they have a certified delegation of authority signed by Congress. Is that your position?
That's my position as well. Okay. There's an Article 5 issue before the court.
Do you want to respond to that? Or? Okay. And again, and then the next argument is that they didn't timely provide discovery within 15 days under Rule 3.220, and that you believe that because of that, the action should be dismissed. That's the second grounds, correct?
Yes, sir.
All right. Now let's go. Now just continue with your arguments.
Okay. And the Sixth Amendment issue is the Brady issue as well as Article 1, Section 16 before the Constitution, because it's clear and it's not ambiguous that if you're going to claim somebody's committed a crime, they have the right to be informed of the nature and the cause of such accusation, which goes back to the ethics issue 3.8. You shouldn't even have filed the action knowing that it wasn't substantiated by probable cause.
Can I ask you a question? Did you get a copy of the citation or anything yet?
The citation?
Yeah, that would be the charging document, I believe.
I think they gave me some documents. I did with the
notice. On the spot.
Okay, no. I have no problem with this. I can address that issue as well.
Yeah.
Because there is no action, as far as I'm concerned, I mean, that's substantial constitution as well, substantive constitutionally. I put no contract on it and sent it back to the lawyer to present within 72 hours.
You put that on the charging the citation you wrote
Yes,
on?
sir. Yes, sir. I don't think that I put that in my
According to this, it looks like, and again,
I didn't set the court date.
No, it looks like under duress.
Under threat, duress, and coercion, because I didn't sign anything without them unlawfully just seizing me and putting me in kidnapping me, essentially.
Is that a copy of the citation? Okay.
Let me say this real quick. I know I keep saying I'm not going to interrupt, but I just think it's very important that along the way we clear up some things that I did not know at the time here. I mean, at the time that I was doing this hearing, that I've learned along the way that no contract, the threat, duress, and coercion issue, that could be a federal rights issue, and depending on your state, how your state's constitution is read, because Don't forget that states have the right to enforce police powers as they wish. But this may have been an issue for what we would call later on, or what I later on came to know as a suppression hearing, to get the stop, thrown out, or to say there's no probable cause for the issuance of the citation that led to the prosecutor charging. It had been easy. It was, as I learned later on, like I said again, it was easier to address the stop itself than it was to address some of this other stuff. It could have just, like, I might have just drug this thing out a lot farther than it needed to be.
Okay, did you get a copy of this?
I have a copy of that, yes.
Okay, all right.
Well, actually, I have the original.
You actually
I don't have a copy. Make
You
sure
actually
the record's
have the
clear on that.
original. It
Right.
comes into either duplicate or triplicate.
That's right. I've received nothing from this.
You actually have probably a smaller version of this that has maybe original writing.
Yes, sir. That would be accurate. And that's what I sent for.
So I agree with you in terms of the request for discovery. I agree with you that you're entitled to that information under the Constitution of the United States and the state of Florida. I agree with those propositions, okay? The remedy is going to be the issue, but I agree with the fact that you're entitled to that information, and you have no arguments with that.
No, Your Honor.
Okay.
It will be signed today, and I
Well-
believe he put an email on Kyle, so it should be circumstantial.
Let's keep going down then. And again, I'm going off your motion or your demand for dismissal, paragraph 4. That's also under discovery request.
Right,
Any
because-
statements you may have made.
Well, allegedly, it could have been made by
Allegedly.
allegedly, as well as any statements that were alleged or not alleged to be made by whomever it is that's accused me, because the state can't be the one accusing me. I want the record to reflect. I'd say I want the record to reflect that as well. I think I may have been redundant with that, just the newness of what have you, and performing it this way. But I wanted to say this. I said something about it earlier about how the ancestors, Most High, and a whole lot of other things were great intervening factors, but one was to have Judge Conrad as the first judge, because later on down the line, I definitely dealt with some judges who were definitely not as, well, I would not consider to be as honorable as he's been in this, particularly his professorial way of allowing me to go through. Some would say he's doing his job, but the way that he handled the court, he didn't jump on me. He obviously had to be able to tell I was a novice at this, but his construing of the context of what I was saying, which is what you are entitled to, liberal construction of your pleadings. You still have to follow the law when you're a pro se, but having him in the beginning really allowed me to develop and grow into what has made me relatively successful as a self-represented litigant. So I definitely have to say, and I guess you can tell with his demeanor, that he's not as awful as some judges I'm sure many people have seen, and definitely not as bad as some of the other judges that I saw in the 13th Judicial Circuit. I'm aware, look, everybody who studied the state is using paper for Tallahassee. So the state's not bringing this argument. I want to know who stated that I've done something to them that would give rise to the cause of action.
Okay, so you, again, to the extent that there is some written document or written statement alleging the basis for the charge, that's what you're requesting, correct?
I'm demanding that, yes.
Demanding, okay.
As well as everything else the record reflect, this is not a motion, this is a demand based upon right, because I know motions can be summarily dismissed.
Well, demand for dismissal.
Okay, there we go.
Okay, so that,
In that demand, you can demand something and he can disregard as well, which then require you to either object to it, or well, you definitely have to object for in the appellate court to even take it up and preserve your objection, and then have a transcript of some sort, because appellate courts, at least in the state of Florida, will only use written transcripts whenever you appeal something. So keep that in mind.
now we have, according to paragraph 4, any written statements by said person, all signed or verified affidavits regarding this case. And then number paragraph 5, you want any police police or investigative reports that might have been generated in response to the case.
And I'm glad that you're reading it, but there's another issue. Let's go back to 4. And probably actually the beginning. I want to know, is the state's attorney, if you're actually a representative or a designated representative of the state attorney, to actually put Mark Over's oath inside of my discovery, the original. Now, I want to know, is it your position that you can be the witness, or are you the one that's verifying that what he said was true, or is there an affidavit that said that it was true?
I don't think she's going to answer your question.
Well, I wanted the record to reflect it more. So the question I'm asking to the court is, who is the accusing party? Because we know it can't be the attorney that's bringing the argument. That's a Transy versus Pagliaro.
Well, I'm not going to answer.
Wow, read that Transy versus Pagliaro. I think many people have misinterpreted how that case works. I'm not going to do it here, but I didn't need to make that argument at this time. Didn't apply.
Well, I'm not going to answer that for them, but in terms of the information that you're going to want to be provided, part of that has to do with a police or investigative report, which you requested. Part of that has to do with the names and addresses of all individuals who may have information relevant to the offense. That should at least answer part of your questions. Also, any statements of any individuals, written statements by that person or verified affidavits regarding the offense. So those all respond to information that you have requested, apparently, or demanded from the state that regard identity and specifics about the alleged offense. Okay?
Yes, sir.
So I understand all that, and I don't disagree with you that you're entitled to that information. With regard to that, any other information that you have requested or demanded that you've not yet getting that's not set forth in paragraphs 3, 4, and 5?
I did a public records request under Chapter 119 of the Florida Statute, the Sunshine Law, with them as well as the Tampa Police Department.
Okay, well, that would be
Not for the outside, but they got the public records. I guess you would be a custodian of records. I stamped it and filed it with the state attorney's office.
That would potentially be something that would be, although related, would be an independent action. In other words, you're filing it under a separate chapter that deals with public entities and institutions and their obligation to keep public records and provide those upon proper demand or request. So that's fine.
That would also be a
entitled to do
constitutional issue,
that.
I believe. It's not,
They're not going to necessarily comply with a public records request to the city of Tampa, correct?
but they're compelled to comply with any public records request in accordance with the Constitution for the state of Florida.
Well, that would be something that, again, from the purposes of what I'm going to be dealing with, I'm going to deal with the issues relating to this case. And if there's information that, under the rules or applicable legal authority relating to a criminal charge that you're not getting, I will certainly address that.
Okay, let me say this. A lot of this, the first couple of times that I heard it, sounded kind of good, but it's now it doesn't sound as good because I've become a little bit more aware. But let me say this: it's better to get to the point. What's the reason that you're there? Address the reason that you're there, and let that be the focus of why you're there. As far as the Chapter 119 request, which is a public records request at the state level in Florida, and you check your own state if you're not in Florida for the public records request. If the information that the city of Tampa has is not necessarily related to the issue before the court, it's not going to matter in the court. The court's going to continue to move the case forward. So I just wanted to say that and make sure I put that out there clearly for everybody. Excuse me. And again, we can move forward if anybody wants if you want more specifics as to what I mean when I make some of these comments. Of course, you can always contact me. But we're going to keep moving along. This is again part 2.
Anything else outside of, you mentioned Chapter 119, that's going to take its own separate
That would be
course.
outside, yes, sir.
What other things do you have here that you've requested that you haven't gotten?
Well, I requested because I'm unclear as to whether I know that Mark Over has been elected, so that's in Article 2, Section 5, and Article 2, Section 8 of the Constitution issue, as well as he's not Article 5 of the EU. But I don't know who is the actual person who is bringing the charge. What prosecutor's name on the record? Because I needed their information to know, so I can know if I have a redress later that they're bringing an action that is supported by probable cause. That would be an issue of what we call later on, we learn later on to talk about, which is a malicious prosecution, which I did have the ability to bring a malicious prosecution action after this case because the outcome did end in my favor. I did not do that. I have another case, actually 3 of them, where the malicious prosecution issue is going to be raised, but not this one.
Because I would need this information if I wanted to file a suppression motion. I couldn't have done that because they haven't done the bare minimum.
Well, that goes to the issue.
To the foundation of the issue, right?
In terms of the identity of whoever you believe is or is not, I believe that whatever documents that you receive in the course of the case, to the extent that those documents are legally required to be found, I think that would be the extent of the information that you're legally entitled to. So you should glean from that whatever you can glean from that for purposes of who's bringing the case. And if you get the documents and you're not satisfied, at an appropriate time we can readdress the issue. But I think part of the demand for dismissal is that there's information that you've requested, you haven't gotten that, and when that information is provided, it may satisfy all of your inquiries, or there may be some lingering issues that you believe are outstanding, and we won't know until you actually get that discovery, which you will get.
Okay. So I guess that right there is a prelude to the fact that we're not going to get this dismissal. But I'll let that be said on the record.
Well, but yeah, we're going to come back to that argument. Okay. And again, I know the information requests. What are the other? I don't know if we've gone through the one through one.
Well, I think we're pretty much through 6 because the competent witness issue is pertinent and absolute germane.
Competent in terms of what? Mental competency or competency? Let me articulate my question. Competency in terms of mental competency or competency in terms of someone who allegedly observed the events about which the person would testify?
Well, mental is kind of, I would think, is broad. I don't understand mental would be whether or not they have a full assertion of the law versus statute, which we know is substantially different now. But competent meaning that they can describe and articulate, which is constitutional, and that would be a Delaware versus Prowse and a state versus pertinent issue. As a prelude for you all to get ready if there is a suppression issue. They have to have an articulable defense, have to articulate it in offense prior to even bothering. Because now my rights are the only ones that now ever had an issue. Have I been violated, which in fact I have been, and I've subsequently.
Well, I think the initial answer to that will be based on whatever the state does provide, and if there's deficiencies in that, from your perspective, we can address that at another court date. So again, I think part of the request or answer to your demand is going to be ascertained through what they give you in response to that.
I appreciate
What's number 7?
We'll make sure it reflects on the record.
Now, before I go with this right here, one thing that I definitely noticed, and it's been brought to my attention by someone who observed me, who actually is a lawyer, said, I probably could help myself if nothing wrong with arguing, because that's what you're there to do, is to argue your case. He said, don't interrupt. So I would tell anybody out there before you get out there, and you'll probably hear me and a couple of other judges get close to the interrupting part, and that's something I need to definitely work on moving forward. It's probably pausing 1.2 or 3 seconds before speaking after the judge is finished.
Now this is chapter 876 of the Florida statute.
We're not in that, but go ahead.
Well, that's where we are. 7. I have something different. My 7 is I demanded on the record for the record. This is within my demand for dismissal, which is scheduled for today, which is the reason for my notice of hearing. It is on the record and for the record, following pursuant to 876 of the Florida statute, an official copy of the public employment oath of all prosecutors, public officials, I have yours and Mark Overs, and policy enforcers and police officers. And to date, none of these requests have been satisfied by an opposing party. Now, I know any of us who have taken an oath at one point or the other, someone can take more than one, know that it's our obligation to satisfy that requirement. And some of us are actually bonded. And that
Your suggestion is you're entitled to the prison oath, you're entitled to a copy of the employment oath?
I'm entitled, I have yours. I'm entitled to the oath of employment. That's 876 of the Florida statute, subsection 5. And there's serious ramifications if we don't do these things that are requested in subsection 6. And then there's 10 as well, and it does cover everybody in subsection 9.
These things being probably unrelated to these things are definitely unrelated to the issues of the stop.
0.05?
Yes, sir.
Okay.
And again, I didn't know this. I didn't know all this at the time that this case was taking place.
And for the record, while you're still
Can I ask
searching,
you a question on that?
yes, sir.
According to that, does the oath have to be in writing or can the oath be administered verbal? Because it seems to suggest that they have to take an oath by someone who's authorized to take acknowledgments of instruments for public record in the state in the following form, and then there is a
Did you read that onto the record for us?
Honor number 2. All right. So it does look like the oath should be filed with the records of the governing official.
Could you possibly read that onto the record? Or do you not want to do that?
Well, it doesn't matter to me. I'll just cite this
I
out.
appreciate it.
76.05. It's page 1004 of the Florida statutes. So.
And as a public official, which would kind of override that, is Article 2, Section 5 of the Florida Constitution, which it also says we have to give a bond prior to taking office. So if these people are,
And that's number 8.
that's number 7.
Well, 8 is the bond.
Oh, it's 2.5.
7 is the public oath, right? An official copy.
Oh, 8 is the bond, right?
8 is the
In
bond.
accordance with chapter 2, Article 2, Section 8.
I'm gonna find that filing from whenever it was back then. I have to figure out what I did with it because that was prior to the electronic filing days. E-filing wasn't something that I was doing at the time. I believe every case after that I started doing e-filing, if not probably sometime pretty soon after that. E-filing is the greatest thing in the world, people. Trust me. If your state has it, use it because it's easy to serve people. Everything is easy to track, and they can't run around and claim what they don't have. So keep that in mind. But as far as a lot of this other stuff, it may matter. Like I said before, if I actually win the case, which in this case, of course, I did, and the other ones I have as well. If you want to bring an issue of malicious prosecution, and I'll say this also in the state of Florida, and I don't know wherever your state is, you want to look for this. People in Florida can go to 768.28 Section 9A, and you'll find something pretty interesting there. That's what in Florida could allow you to pierce the veil of qualified immunity as it relates to public officials' performance of their duties, and it has to do with malice. Y'all might want to check that out, and if you're in another state, check out and see if your state has a similar statutory way of going around that qualified immunity. Because don't forget, the federal court level, you're not going to be able to deal with the issue of qualified immunity necessarily. But if you can have them supplementally from the same event, use that state statute up at the federal court level, you might be able to get something to move in your way. And I can better articulate that at another time as far as supplemental jurisdiction for the federal courts if you ever file an action in the federal court.
The basis of public office.
No. You have a copy of this.
Yes, I do have a copy of the motion.
Of this. It's a demand for dismissal, but incorporated within the demand for dismissal are also other demands that are not dismissal related. There are just other demands for information and other things like that. So we'll go back to the issue of the
One moment. For clarity purposes, those issues do become relative if the person who is actually operating within the function doesn't have the authority to operate within that function, then they're operating outside the law, so that is relative and pertinent.
Well, I'm not going to at this point rule on the issue of relevancy or not. I'm just going to make sure that for purposes of what's been demanded on the record, that you're aware of that, and based on that, the state can make whatever appropriate reply they want to those items, and we'll see where that goes. Okay?
Now, here's something that was interesting, and I know that the Florida jurisprudence is not necessarily a Gibraltar-style rock for legal precedents, even though it kind of covers certain things. It states quite clearly, if you want to copy this one, that as far as general rights or declaration of rights, and you go to paragraph 1, actually, it's about the
What
third.
are you referencing? I'm sorry.
The Florida jurisprudence. I want the record. You see, these are important rights of the accused and cannot be legally invaded by the too strict application of judicial or statutory rules of evidence or procedure. Now,
I'm sorry, but I don't know what. You don't have to give it to me, but you can read it. But the references what?
As far as certain rights, and the thing is, I don't believe in coincidence, my honor.
Do me a favor, though. You're making a context. The heading of the article you're reading.
Oh, it's the General Declaration of Rights. Generally, it's called the Declaration of Rights under criminal law, and this is from the Florida jurisprudence.
There's something that we call taking mandatory judicial notice. Take a personal note of that, and if we ever have another discussion, either on Blog Talk or somewhere else, we can talk about those kind of things. Some of that I don't think really matters. Plus, I want to make sure he gets to a couple of other points. And again, Judge Conrad is doing a pretty good job. He's doing actually a great job. I'm doing a job, I guess, moving the case along to get to what I needed in the end. But again, took a lot longer than it really needed to, and that's my fault.
Okay. It's not specific to any one issue. It's just whatever your rights are.
Well, they cite O'Berry versus State, and this is 1904, and we know that that's been otherwise overturned, which I don't have any proof. If you can provide that, I would appreciate that because I'm making that orally on the record. That once these things have become an issue in the courts rule, they're substantial law.
But what issues are you talking about?
That you can't create a rule and then operate outside the rules.
I'm not sure which one, but I don't know the
Well, they had the 15 days. She's already acknowledged on the record that she got
right. But again, here's the thing that's going to be challenging for you and probably challenging for me as well, because I may not agree with you on things that you're suggesting. I'm going to follow the rules of criminal procedure as have been interpreted by the Florida courts in application. Okay, I'm not aware of a per se rule of dismissal that occurs when someone doesn't timely file or respond to a discovery request. Okay, if you have authority, you want to come back to me and say,
well, I will do that.
I'd like to speak for almost 40 minutes now. If we wind up coming back and you say, Judge, under State versus Smith, hypothetically, they did not respond to me in writing within 15 days after receiving my demand, then I'm entitled to an automatic dismissal under this case. If that's what it says, I will follow that law, obviously, and if the request or what you're asking for is legally supported, I'll grant the request. I'm just telling you, I've done this, obviously, for some period of time. I'm not aware of any legal authority in the state of Florida that would suggest that a failure to timely file a response to a request for discovery requires an automatic dismissal. And actually, it would probably be overturned if I impose the sanction of dismissal without giving the state a reasonable opportunity to comply with the request. So as to that, I'm going to note your objection on the record.
I will make the objection on the record today.
Your demand for dismissal based on the failure to timely comply with discovery. I'm not going to grant the dismissal at this point. What I am going to do, though, is I am going to, based on the writ of discovery that he provided, okay, what he's requested, I'm going to order the state to provide that information to you within 10 days from today. It'll be today anyway, but I believe it'll be 10 days from today, and today is June the 10th. So they're to provide that information to you no later than Friday, June the 20th by 5 p.m. And in the event that you don't get that information provided by them, I will entertain sanctions at that point in time, okay?
Sanctions to include and up to dismissal of action?
It could, yeah.
All right, I just want the record to reflect.
Now, do they have...
Now, before I let him finish, and we only have a few more minutes, so once we get to about the 30-minute mark, it's pretty much filler. I'll come back and later on that day, but Judge Conrad is absolutely correct, and I wanted to touch on a couple of things. My frustration, even in this, hearing it in my voice at the time, and probably you hear it now because I'm thinking, wow, I was really a jackass in some instances, but I made it through there, is a lot of my frustration then was based upon my ignorance and just wanting a dismissal of the action, which is, I'm sure everybody can understand. E-file, like I said, the e-filing thing came out a little bit later, but he is liberally construing my motion for dismissal, whatever it is that he's looking at. I know it's a motions hearing, but in other words, what he's doing is he's taking what is probably not what they would consider legally sufficient writing, looking at it and allowing me to explain what it is that I want, and he is interpreting that. Now I want to make sure this is clear, people. Even if you're a pro se, you get you're entitled to liberal construction. Look up that for yourself. But we have to stay within the confines of the law. You know, we still have to operate within law. So, and that's just what I've learned through my experiences. My experiences have taught me that. So there may be some other people with other experiences, but I'm just showing you and giving you a narrative of what was going on in my mind at that time versus where I am today, so that as you put all these other videos that come later on down the line for other cases, you'll see the evolution in the information I had as a pro se. And by the way, per se means as it is, or it speaks for itself. So that's what per se means. So in other words, show me where, because they did this, that in and of itself constitutes this response from the court.
Have information? Do they have contact information for you, Mr. Dawes? They know where to mail it or how to get it to you, or?
Absolutely.
Okay,
I'm here, right?
Well, they don't have. I wish they had it here to give it to you, but they don't. But they're going to have to mail it to you after today, and I'm assuming it'll go out today.
If we have the proper contact information on the
You can hand it to me now.
She doesn't have it now. Let me ask you a question.
We don't give hard copies anymore due to the new e-filing procedures.
Well, you
It's all
have
done
to.
electronically.
It's not email. You got to.
I don't have, can you show me its request for discovery? I can tell you if there's an email address or contact information at the bottom. I don't have it right now.
Okay, but let's do
No,
this.
we already said on the record receipt. If you said
Wait,
to go to
wait,
contact me.
wait, let's do this. Okay, you said you got the writ of discovery, correct?
Yes, I have it at my office, Your Honor.
The writ or the response?
The request for discovery.
And where's the response?
My response is at my office waiting to be signed.
And what's the impediment to signing it today?
Nothing, I'm going to sign it as soon as I get back to the office.
Okay, now let me say one more thing, okay? Do you want to, if I have court at 1:30, you'll be back here at what time? Well, I want to put it on the record, so you want to come back today at 1:30 and get it?
I don't want to make that commitment because I have to pick up my children. More importantly, I have to authenticate something.
Okay, well then they're going to have to mail it to you.
Well, what I will do is she'll be here from 1:30 to when? To what time? You here till
Well,
5?
you come here at 1:30. I'll call it up right off the bat.
I can't make the 1:30.
Okay, then she's going to have to mail it to
Okay,
you.
well, then the information you have is
Give her an address where you will receive.
You can send it care of 3612 North 55th Street, Tampa, Florida.
Let's do this. We're going to have to get a little slip of paper, a little sticker or something.
Well, we have a citation that they put there.
Well, then just say it's on the citation. 3612 North 55th Street, Tampa, Florida 33619.
Yes, sir.
Okay, there you go. So that's the address that
That
you.
the citation will work.
But I'm giving you the choice.
Well,
You can come back at 1:30. She says she'll have what she has. She's going to give it to you. And if you don't want to do that, bring it at 1:30. If you're here, we'll do it. If you're not, she'll
Yes,
mail
sir.
it
I
out to you
appreciate
at that address. Okay?
Yes, I just want to commit to something. And more importantly, I want to make sure that the record reflects that because most of us are under some sort of oath, I do accept on the record, before the record, all oaths of all public officials. And I expect all of us to operate within our capacities as we should. Now, and I just want that to be on the record, before the record.
Well, here's what I'm going to do as to let's do this. When are we going to come back?
And I just ask me, you want
Could
to
you respond
just
to
ask
the argument? And we'll have to take a look at that. As to your grounds for dismissal, as to number or alleged in paragraph 2, paragraph 3, paragraph 4, paragraph 5, paragraph 6, which they all deal with the information.
Your Honor, before you
No,
go.
don't interrupt me now. Okay, I've given you 40 minutes of
I wanted to
valuable
ask her
time,
if she
and
wanted to
I'm not-
dismiss it.
I'm going to tell you what I'm going to do, and then we're going to be done. All right, 2, 3, 4, 5, 6. As to those, at this point, I'm going to deny your demand for dismissal. I've already in order compelling the state to provide the information under Florida Rule, the 3.220 Florida Rules of Criminal Procedure. When you receive that response, if there's any outstanding issues that you believe need to be addressed, you certainly are welcome to bring those back to me by appropriate motion, okay? As to number 7, number 8, again, at this point, that's going to be something that I'm going to deny a motion to dismiss, although that's not a motion, kind of is, but it's a demand and a motion or a request for dismissal. I'm going to deny that at this point without prejudice to you to refile in the event that the information that you requested is not otherwise provided to you, okay?
Yes,
the only other issues would be under paragraph 1. I'm going to reserve ruling on that. I'll take a look at Article 3 as well as 28 USC subsection 3002, and then I'll make a decision whether it's applicable or not applicable, and then I'll make a ruling on the record with that. How quickly do you want to come back? Do you want to set the case for trial?
I guess I could do a memorandum of law in support of the reasons for dismissal prior to their 10 days running out.
Okay, let me ask you a question. This said is, we should be able to do it. It's set for July the 1st, right?
Yes.
Okay, so we're still on track. If you need to get something addressed before then, outside of potentially if I don't dismiss it or impose sanctions, if you need to get it addressed at some point before that, you're going to have to call my assistant and get a date. So if you mail that out today, you should get it by Wednesday, I'm hoping, or no, Thursday. And if there's any issues, call my office, and if we need to set up additional hearing time before July the 1st, we'll do that, okay?
Should I mail it today, or should I bring it to court at 1:30?
Bring it to court at 1:30, even though we're just going to put that out there, and if not, I'll mail it by the end of business today. I'm sure you'll have time to do that.
Yeah, I just have to get it printed out.
And then I guess we could, if we're going to reapproach it, if that's the case, then they can.
You're the one.
Well,
I'm not reapproaching anything at this point.
Well, I guess there's always the question of what's the offer, and the question is also, I guess within that offer, they could offer to just not prosecute the action.
I don't think they're inclined to want to do that, but
I'll let them answer that. That's what I can say on the record. I appreciate that.
Okay, so let's do this. We're going to see you back here. July the 1st at 9 o'clock is still the trial date that we're going to have. However, if you get any information, and I want to make sure you have to know how to do this, you have a seemingly a good understanding of what your arguments are, make sure whatever you want me to consider, you file with the clerk, because if they're not filed with the clerk, they're not a matter of record, and then whatever arguments you're going to make are not going to be able to be heard because they're not filed in the official court
That's why I
file.
was kind of concerned because
Well, she's saying she didn't have whatever, so.
that's stamped by the clerk.
What's that?
Something indicated by the clerk.
Yeah, show them that. What is that?
I have everything which I did.
Was that received in court or not?
No, Judge, that wasn't.
What is that?
I'm not sure. It's a stamp that says as long as it's received now. I'm not sure.
Is that your stamp or you don't know?
It's probably from front camera. I'm not sure what stamp that they're using about it.
There's two. There should be one for the
Okay,
state
we
attorney.
need to have that. We need to know where these documents are then, okay? Because it looks like from original pleading filed, that was on June. Well, when was this? This was June.
That would probably be for the notice of hearing, but
Well, this was the demand for dismissal was June 3rd, so that should be in there. You can give that back to
as
us.
well as the one for the notice of hearing. But I'll make sure.
But again, make sure if you want another hearing date before your July the 1st, call, you did it before, just call my assistant, tell her why you're calling, and that the judge said to get you scheduled, she'll coordinate with me, and we'll bring out any other matters before it's set for trial and then trial date. All
I
right, sir?
appreciate that. You have a
All right,
great day.
thank you. All right, anything else on the record? All right, court's adjourned. Us. Here we go. Mr. Alcanti, Mr. Dawson is present in the courtroom.
Yes, I'm more.
All right, you want to hand that to him?
I just need to have this to decide, or only the official one needs to decide. The one that I'm filing with the court this time, and usually the ones who send to the defense attorney are not physically
I
signed.
don't care. You can sign if you want.
Now it's on the record that I'm receiving it. If that's what you want me to do.
I don't want you to acknowledge anything. I
Okay.
just wanted to make it easier for you to get it. And again, if there's anything you need to follow up, Mr. Doss, get my assistant, and we'll give you more time if you need that.
I
Okay?
appreciate it.
All right, thank you. Say versus.
Okay, so that right there would get rid of that little piece that we had to take care of. So now let me move this to the side. Not that I guess it matters. So here's where we are at this point in this proceeding. We've gotten through. We've gotten through my initial motions hearing, where the judge compelled the state to give me the information that I asked for. I don't even remember what it is. I'm going to go look for it. I can almost guarantee you that it's a bunch of things that may not necessarily have gotten me to remedy as quick. It may have been a lot of what I'll call internet filler that over time I kind of learned how to get rid of. The issue, the basics of anything is going to boil down to issue, rule, analysis, conclusion. They have CRAC, they have a bunch of other things they teach them in law, but always know IRAC, the issue, the rules, legal analysis, and conclusion. Also, focus on getting to your point, which is what I definitely wasn't doing a good job at. In here, I'll say that as a critique myself. When it comes to crime or criminal law, probable cause, reasonable suspicion, making sure that you focus on what that is so that you can hopefully move towards suppression. If you suppress, like in this case, a traffic stop, and there's some other issue after the stop. In my case, they were claiming the issue after the stop was I had the license. There was no other issue other than they stopped the vehicle and there's a license issue. But there was only one citation, so there's no accompanying reason to articulate the stop. And then we may have a violation of the Fourth Amendment with that right there. I guess I must have filed a writ. I'm looking at some notes that I was listening to this myself. Improper. I should have just labeled it as a motion. Even a demand is fine, but in this case and in this court, a writ wouldn't be necessary. But one thing that is definitely, hopefully, coming out to those who may not know is know the process, know procedures, and things would tend to work well. Judge Conrad did a good job of helping us all out. So, with that being said, hopefully we all got a little something out of it. You can see my information here on the screen. If you'd like to support the channel, you see the CashApp, the Zelle, the PayPal. And if you just need to ask a question or two, you can go to gregdoss.com and put your information in there. I'll get your email, and we can go with it from there. So I will get started, or be looking probably within the next couple of days from the release of this one for the part 3 to the case of 14 CT 66525 involving me in the state of Florida, but which will ultimately end with me winning the case. Y'all take care.